One of the biggest concerns when a relationship ends is how to divide property and assets. Unlike heterosexual married couples in Singapore, LGBT couples do not have access to the Women's Charter. Hey everyone, welcome back to the channel. Today we're diving into an important topic for long-term LGBT couples. While ending a relationship is never easy, understanding the legal considerations can help make the process smoother. Ending a long-term relationship involves more than just emotional decisions. There are several legal aspects that LGBT couples should consider to protect their rights and interests. Here are a few points you need to know. Number one is property and asset division. One of the biggest concerns when a relationship ends is how to divide property and assets. Unlike heterosexual married couples in Singapore, LGBT couples do not have access to the Women's Charter. Instead, you need to rely on general contract law and principles of equity. If you own property together, determine whether it's held as joint tenants or tenants in common. Joint tenancy means that both parties hold the property as one. There are no shares. And there's this doctrine called the right of survivorship. You can watch my earlier videos on joint tenancy and the right of survivorship. On the other hand, tenancy in common allows for equal shares or unequal shares, and there's no automatic right of survivorship. If you and your partner own property as joint tenants, it is important to make sure that one party buys over the other party's ownership, because the survivor will get the whole property in the event the other party dies. Even if they have broken up, and even if the person who died executed a last will and testament, purporting to give his share of the property to somebody else, because the doctrine of survivorship supersedes any such bequest in a last will and testament. Next consideration are pets. Pets can feel like family members, and deciding who gets custody can be challenging. Legally, pets are considered property, so their custody will be part of the asset division process. First, if there's any dispute about ownership, look for ownership proof. Have documentation like adoption papers or receipts to show ownership. You should also consider care arrangements for the pet's welfare and make arrangements that prioritize the pet's best interests. Third issue to consider, debts. Any shared debts, such as joint loans or credit cards, need to be addressed. Both parties remain liable for joint debts unless there is an agreement to the contrary. Decide who will be responsible for paying off shared debts. This can be negotiated between the parties or mediated if necessary. Be aware that failing to settle joint debts can affect both parties' credit scores or rating with the credit bureau in your country or jurisdiction. Number 4, living arrangements and leases. If you are living together, you will need to sort out your living arrangements. This involves checking the terms of your lease. If both of your names are on the lease, check with your landlord about terminating the lease early or transferring it to the other party. Be mindful of the notice period required to terminate the lease or to make changes. Number 5, legal documentation and agreements. To formalize any agreements made during the breakup, consider having them documented legally. This includes separation agreements, which outlines the terms of your breakup and could include asset division, debts, pets, and living arrangements. Engaging a mediator or seeking legal advice can help ensure that the agreement is fair and legally binding. Now, the last and most important of all, revoking wills, lasting power of attorneys, and other legal documents. Another crucial step is to update and revoke any legal documents that give your ex-partner legal powers, such as wills and lasting powers of attorney. If your will names your ex-partner as a beneficiary, executor, or guardian, you should revoke it and create a new one. This ensures that your assets and responsibilities are being managed according to your current wishes. Also, if your ex is named as your donee in a lasting power of attorney, you need to revoke the LPA and create a new one. This prevents them from having legal authority over your financial and personal matters in the event you do lose mental capacity after the breakup. Finally, review any other legal documents such as healthcare proxies, insurance policies, power of attorneys, and bank account authorizations to ensure that your ex-partner is no longer listed as having any control or benefit. Ending a long-term relationship is never easy, but understanding the legal considerations can help you manage the process more smoothly. If you have any questions or need legal assistance, feel free to reach out. Remember, you're not alone and there are resources available to help you through this challenging time. Thanks for watching. Don't forget to like, share, and subscribe. See you in the next video.